Hey guys, and welcome to today's video. Today we have another sovereign citizen, living man trying to use the soft set script in court. Now today's video will consist of 2 of his pre-trial hearings as we prepare for a few jury trials coming up. And oh yeah, I also think he has a brother-uncle on trial in a different jurisdiction, but we'll get to that video in the future. Now, before we get started, I'd like you to know that this guy is dumber than dogs, so get some facepalm protection, and let's begin.
5M42624 M439. And good morning. Can you tell me your name, please?
Jared Mark of the family Sullivan.
People, what is the outcome of your conversation, Mr. Sullivan?
Your Honor, Mr. Sullivan indicated to me that these are likely going to become trial cases. I do have a note in the file that Mr. Sullivan filed a discovery demand, but has not yet come to our office or requested that discovery in any way. So I did inform him that he can go upstairs to our office and request that discovery. I also offered to provide the Larimer County website where you can make a discovery request, but he did not want that website written down for him. So I've instructed him up to the second floor to request that discovery after this court date.
Okay. Mr. Sullivan, what are you asking the court to do today?
Well, I'd push for another dismissal based on failure to state a claim.
Your motion to dismiss is settled, and I will no longer be considering any more motions based on the grounds you previously asserted.
Well, and your response to that is just adding claims on the record that haven't been brought up by either parties. And it leaves the appearance that you're acting outside of the bounds of your duties as an independent third party.
You are asking me to review motions and issues that I reviewed, I think, last year and already acted on, and I'm not doing that again.
Do you have an oath to the Constitution on record, sir?
Beg your pardon?
Do you have an oath to the Constitution on record?
Sovereign citizens seem to think that by not consenting, challenging jurisdiction, and asking obvious and obviously stupid questions like, "Do you have an oath to the Constitution?" is some magic phrase that unlocks a level 69 get out of trouble spell. I hate to be the one to tell you, but it doesn't.
Discuss this, and so we're going to move on. You are choosing to...
Do you have an oath of office on record to the Constitution, sir?
Sir, you may not interrupt me. I'm going to go through, you are choosing to represent yourself, is that correct?
Yep.
Then I have to ask you some questions. And I think I've asked you this before, but we'll go over it again. Are you currently under the influence of any drugs, medication, or alcohol that would affect your understanding of these proceedings?
No.
Do you understand that you have the right to be represented by an attorney throughout these proceedings?
Yes.
Do you understand that if you cannot afford an attorney, that an attorney can be provided to you at no charge to you if you qualify financially for that service?
Yeah, we've already done that.
I know, but do you understand that?
Yeah.
And do you understand that I would appoint counsel to represent you if you wanted an attorney to represent you, provided you meet that financial eligibility requirement? Do you understand that?
Yes.
Do you have any legal training?
No.
How far have you gone in school?
Some college?
Do you understand that the criminal law is a complicated area and that an attorney trained in this field could be of great help in preparing and presenting and representing your defense?
No, I don't understand that because I haven't seen evidence of it.
Because what?
I haven't seen evidence of that, especially through the attorney that I was provided that offered ineffective assistance of counsel.
Well, all I'm asking is, do you understand that the criminal, I'm not asking you about the specifics of the case. Generally, do you understand that criminal law is a complicated area and that an attorney trained in this field could be of great help in preparing and presenting your defense?
In theory, yes.
Do you understand that you will be held to the same rules and laws as an attorney would, even though you do not have the same training and qualifications of an attorney?
No.
You don't understand that? I will explain it. You will be held to the same rules and laws as an attorney, even though you don't have the same training and qualifications. For example, The district attorney just discussed discovery. An attorney who is trained and qualified knows that they have to make a request to the district attorney to disclose the discovery. The district attorney doesn't just automatically provide it. Once they get that request, they will provide what they're required to provide under Rule 16 of the Colorado Rules of Criminal Procedure. The district attorney has said that you have not made that request yet. So that would be an example. So if you came back at trial and told me they never gave you discovery, then I would hold you to the same rules and laws as an attorney would be held to, which is that if you didn't request it, then that's on you, not them. So that's an example of you being held to the same rules and laws as an attorney would, even though you do not have the same training and qualifications as an attorney. So do you understand that?
I don't, because my attorney, the ineffective assistance of counsel that was provided by the court, had already requested that discovery. And I keep filing the same discovery requests because they refuse to release it. Exculpatory evidence.
So I'm not, again, asking you, I just used an example from your case to illustrate the general idea. The general idea is, do you understand you will be held to the same rules and laws as an attorney would, even though you do not have the same training and qualifications as an attorney?
Sure.
Keep what he just said in mind, because the judge has already warned him that he should be expecting to be treated as if he's an actual attorney, even though he's representing himself, because he's going to be complaining about his disadvantages later in today's video.
All right, court will find that decision is knowingly and voluntarily made. So in 25M426, what is your plea to obstructing a peace officer, guilty or, well, actually, I should probably have the people recite the last offer communicated to Mr. Sullivan on one or both of these cases if it's a global offer.
Yes, Your Honor. In 24M439, the last offer was to plead to original count 1, no proof of insurance with a $500 fine and 4 points against the DMV. In 25M426, the last offer was to plead guilty to original count 1, obstructing with 6 months of unsupervised probation, an ISAE discovering better choices class within 5 months, 16 hours of UPS within 5 months, and to remain law-abiding. Both of those offers are now revoked.
Well, we'll get there in a minute. So in 24M439, if the plea of guilty is to count 1, does that, am I correct in inferring the offer contemplates dismissal of the remaining counts?
Yes, Your Honor, I apologize.
Mr. Sullivan, did you hear what the district attorney just communicated?
Yes.
If you enter a plea of not guilty, all of the, you will be communicating to the district attorney you would not accept that offer. You'd be communicating, and the district attorney is free to withdraw it. And if they choose to withdraw it, they may choose not to put any new proposals on the table for a resolution of either case, which may leave the trial that I set as a result of your not guilty plea as being the only way to resolve the cases. Do you have any questions about that?
No.
So in 25M426, what is your plea, guilty or not guilty?
I do not consent to enter any plea on my behalf. I do not comprehend or understand how to enter a plea, as there is no injured party in this matter and no evidence of any contractual obligation requiring performance to follow the corporate state of Colorado statutes, codes, ordinances, and rules that are merely policies of the corporation acting as government under the color of law outside the bounds of the constitutions of the United States and the state of Colorado.
All right, so it sounds like you're refusing to enter a plea. Is that correct?
Yes, sir.
Then the court will enter a not guilty plea on your behalf. On 24M439 to count 1, driving without insurance, count 2, obstructing a peace officer, count 3, driver's license refusal to display, count 4, fictitious plate. What are your pleas, guilty or not guilty?
I do not consent to enter any plea on my behalf. I do not comprehend or understand how to enter a plea, as there is no injured party in this matter and no evidence of any contractual obligation requiring performance to follow the corporate state of Colorado statutes, codes, ordinances, and rules that are merely policies of the corporation acting as government under the color of law outside the bounds of the Constitution of the United States and Colorado State.
So it's, am I also correct in inferring you are refusing to enter a plea in 24M439 as well.
Yes, sir.
Court will enter a not guilty plea on Mr. Sullivan's behalf. Are you requesting a trial to the court or a trial to a jury on these two cases?
I'm demanding a trial by jury.
All right.
And are you planning on scheduling those back-to-back, Judge? Was that my understanding?
I beg your pardon?
Are these trials scheduled back-to-back?
Right. So if one will go and the other one will get continued.
All right. So that's the end of his initial appearance. He, of course, didn't please. So that means that his speedy trial clock hasn't even begun yet. Now we're going to head to his next appearance. And this is where his true ignorance shines in the spotlight.
Mr. Sullivan, are you ready to proceed to trial?
No, I don't believe so. Well, maybe on the 439 case.
Yes,
I know that.
yes or no answer to know how to proceed next.
Well, I was prepared. I didn't know we were splitting them back up.
Beg pardon?
I didn't know that we were splitting them back up.
Why we're splitting them back up?
Well, they're scheduled for the same day for this trial next week.
Right. They wouldn't both go to trial at the same time. One or the other would go.
Okay. Well, then, yeah, I can do 439.
All right.
And that 426, I'm still waiting for discovery and disclosure of witness names.
Then I will note that the deadline for resolution is February 23rd at 12:30 p.m. Will you be requesting the new reasonable doubt instruction?
Yes, sir.
The new reasonable doubt instruction reads as follows. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. If you are firmly convinced of the defendant's guilt, then the prosecution has proven the crime charged beyond a reasonable doubt. But if you think there is a real possibility that the defendant is not guilty, then the prosecution has failed to prove the crime charged beyond a reasonable doubt. And a reasonable doubt can be based on the evidence presented or the lack of evidence presented. New reasonable doubt. Are you going to have an objection to me reading that reasonable doubt instruction to the jury?
Sorry, me?
Yes.
I'm fine with that. That's fair enough.
People, how long are you asking for voir dire?
It's 10 minutes, Your Honor.
Mr. Sullivan, how long are you asking for voir dire?
For what?
Voir dire.
I don't know what that is.
Yep, he's in trouble. Dire comes from the Old French language, and it literally translates to true to say, or, as we would say in modern English, to speak the truth. And it's the process where the judge and lawyers question the jury pool under oath to uncover any hidden biases. Even though we call it jury selection, it's actually a deselection process. And it's your chance to identify and remove jurors who can't be impartial before the trial even starts.
It's the process where you ask the jury questions to find out ahead of the jury being selected whether or not the people who are called to serve as jurors can be fair and impartial.
Is that between individuals or in
Mr. Sullivan, you may recall when I gave you an advisement that said that if you're choosing to represent yourself, you need to understand that you will be held to the same rules and laws as an attorney would, even though you don't have the same training and experience as an attorney. So I'm not planning, I'm really not able to coach you through this process. I'm expecting you to come to court already having this knowledge of what will be happening at a jury trial.
Well, all I can do is guess at this point.
Or you could get a lawyer and remove all guessing.
Let me put it this way. We will not slow the trial moving forward because you are not knowing or understanding things you should know or understand ahead of time. For example, voir dire will be 15 minutes in length, regardless of how long, once you have figured out what voir dire is, how long you want to use on voir dire. It'll be 15 minutes in length. How long are the people requesting for opening statements?
5 minutes, Your Honor.
Mr. Sullivan, is 5 minutes going to be long enough for you to make your opening statement?
Maybe go 10.
The court will allow 5 minutes for opening statement because what needs to be, what is stated during opening statement is a recitation of facts. It's not argument or commentary on the law. And 5 minutes should be adequate to cover that. People, how long are you asking for closing?
10 minutes, Your Honor.
And sir, how long do you think you need to close?
I imagine that'll work.
Beg your pardon?
I imagine, well, clearly you're just gonna say 10 minutes, so I'm gonna say 20 minutes. Because I'd rather have extra time, whether I need it or not,
Well, I will allow
than
15
getting cut
minutes.
short.
I will allow 15 minutes for closing because there are 4 counts. Those counts do not all rely on the same evidence. So there may need to be a little bit more argument regarding how the facts fit or don't fit with those elements. Will any witnesses need special accommodations, people?
No.
Are you planning on using the courtroom technology?
Yes, Your Honor.
Mr. Sullivan, were you planning on using your computer to publish exhibits to the jury?
To my knowledge, that's the only way to do it, is if I bring my own
I
equipment.
don't understand what you're saying.
To my knowledge, that's the only way to do it, is if I bring my own equipment, right?
Well, no, you can have paper copies and share them with the jury by having them look at paper. The reason why I'm asking, if you're planning on publishing with a computer, then you will be using the courtroom technology to accomplish that. And again, it's a situation where you need to be ready to have that going, because I'm not going to wait to troubleshoot issues. We won't be troubleshooting issues in front of the jury.